First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this afternoon. The case of Rockwell at Amelia Passage, LLC versus Louise Williams et al. Counsel ready to proceed. You may approach, counsel. Counsel, we've allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. I would reserve 3 minutes for rebuttal.
So noted, Madam Clerk. You may proceed, counsel.
May it please the court. We're here because the lower court essentially tried this case on summary judgment by making factual findings, notwithstanding conflicting record evidence that raised a number of disputed issues of material fact. Appellant respectfully requests this court reverse the summary judgment and remand the case for a trial on the merits. The focus of my argument today will be on the summary judgment issues related to the disputed issues of material fact and the legal errors making summary judgment improper. I intend to rely on the briefs as to the issues of the timing of submission of summary judgment evidence unless the court has questions. The first issue I want to discuss is that the lower court erred in finding that the feasibility study period under the contract had already expired on November 30th, 2019, thereby making the COVID-19 events and delays in 2020 irrelevant. By way of background, the parties' contract contained a feasibility study period in paragraph 8A1 that allowed the appellant time to determine if the property was suitable for its intended use, which was as a residential development. That included work to determine the availability of permits, government approvals, and licenses, and also obtaining any needed rezoning from appropriate government agencies. Now, the record evidence includes deposition testimony from Dwight Griffiths from the appellees that the appellees understood that appellant needed to obtain rezoning for its intended use of the property. The paragraph 8A also provided that prior to the end of the feasibility study period, the appellant had to give notice whether the property was acceptable, and if it failed to give the notice, then the property was deemed accepted as is, and the appellant was required to close. The closing date under the contract was set for 30 days after the end of the feasibility study period. By addendums number 2 and number 4 to the contract, the parties extended the feasibility study period to November 30th, 2019, and the closing date to December 31st, 2019. Although appellant did not provide the notice by November 30th, 2019, 3 days later on December 3rd, 2019, the parties executed addendum 5 to the contract.
Am I correct, counsel, that to prevail here on appeal, you would need both the 5th and 6th addenda to extend the feasibility study, as well as us to find error in the force majeure finding, correct?
Yes, that is correct.
So if the trial judge was right on either one of them, then we should affirm. Is that right?
Yes, Your Honor, but I would submit the trial judge was not right.
Sure, I understand
for the
that
reasons that I'll
disagree.
explain. So then the parties also signed addendum 6 on April 29, 2020, in which they again agreed to extend the feasibility study period and the closing date, the feasibility study to October 31st, 2020, and the closing date to November 30th, 2020. There was record evidence from the appellant that its intent was by these addendums to extend the feasibility study period and the closing date. The lead negotiator for the appellees, Mr. Griffiths, Dwight Griffiths, also testified in his deposition that these two addendums, 5 and 6, extended the feasibility study period. A reasonable jury, Your Honors, could find, based on that record evidence, that the parties did intend to either reinstate and or extend the feasibility study period through these addendums 5 and 6. Otherwise, what would be the point of those addendums that extend the feasibility study period? At a minimum,
counsel, as far as the extension, the last extension was April 30th of 2020. Is that right? So by that time, the COVID pandemic was unfortunately well underway on TV all the time. Apparently, the planning board had already canceled some meetings. So why does the COVID pandemic then implicate the force majeure clause in the contract?
Well, for a number of reasons, Your Honor, because while there had been some meetings that had been canceled, it was in flux, and there's testimony from Douglas McDowell, the county planner, that the issues related to the pandemic were causing cancellation of meetings on a piecemeal basis, and they didn't know how many were going to be canceled or when the cancellations would stop.
But they resumed, though, back in July of 2020. So how did the pandemic, assuming the force majeure clause even applies to COVID, which might have been reasonably foreseeable, how was the pandemic such that it affected the completion of the feasibility study?
Well, Your Honor, it wasn't just the pandemic. It was the effect the pandemic had on the county and what the county was doing and the county's responsiveness to appellants' efforts to complete the rezoning. There's record evidence that, for instance, in June of 2020, the county had requested a revised application related to the land swap and the school concurrency issue. And just as background, initially, that was the way that the appellant was going to meet the school concurrency requirements, to do a land swap and give the county or the school board land for a new school. After the pandemic hit, there were no more discussions on that. The county essentially went silent, in large part because they weren't able to respond timely.
But in July then of 2020, the school board gave you 60 more days to try to get the concurrency completed. And when it wasn't completed in September of 2020, the planned urban development proposal was withdrawn, right? So how does COVID affect any of that?
So what happened, Your Honor, was there was about almost a 53-day delay between the last submission that incorporated the land swap, and there was no response from the county one way or the other as to whether the land swap was a problem. And prior to this, the land swap had been the way that this was going to proceed. And so those 53 days in between the time of that submission with basically nothing, no response from the county, and then when they finally did get a response after that inordinate delay, the response was, well, we're not going to do the land swap anymore. You got to figure out something else. And that was what caused the appellant to have to shift gears. But at that point, they had already lost those 60 days, and things were also backed up because of the way that the meetings had been canceled. And so they essentially ran out of time in trying to switch gears to go to a smaller development that would have a lower school concurrency requirement. And the record evidence I would submit, Your Honor, a reasonable jury could look at it and make the inference that these delays by the county were related to the COVID-19 pandemic, particularly with related to the land swap.
How do you respond to the trial judge's finding that the complaint for declaratory judgment and Mr. Vo's affidavit spoke only of the planned urban development and not of rezoning? So that given that it's undisputed that the planned urban development had expired or the application for it had expired or been withdrawn by September of 2020, the rezoning is not mentioned in either one of those things.
The rezoning actually is mentioned in the affidavit, Your Honor, of Mr. Vo. I agree it's not mentioned in the complaint. It should have been probably more artfully pled. As the case progressed, that became an issue that when the issues related to the school concurrency became higher to the forefront, that became a bigger issue. Conceitedly, that should have been.
Well, doesn't the rule require the pleading to be one of the things the court considers? I mean, isn't that subsumed within the rule? The pleading has to be part of the court's determination?
Yes, Your Honor, the pleading is part of the court's determination, but I would submit that the court is not bound by only what's exactly in the pleading.
Why is that? I mean, I'm just trying to understand, because the rule does say pleading. My understanding of the rule based on the pleading. So doesn't the rules mention of pleading cause us to be bound by what happened here, the fact that this was not pleaded?
Well, I would submit that what's in the affidavit is further clarification and detail upon the pleading, in the sense that it talks about rezoning, and it's the same concept. It's just that the PUD did get pulled and a new rezoning was submitted, And if you go back to the contract, it speaks in terms of
You're
rezoning.
not saying, and I just want to make sure I'm clear about this, you're not saying that the affidavit amended the pleading somehow, are you?
No, what I'm saying is that the affidavit was part of the mixture of record evidence that the court could look at and apply to the pleadings.
But isn't the court duty-bound, I mean, as a threshold matter, don't the pleadings frame the case? I mean, isn't that what pleadings do? They frame the case for the court and the parties. You would agree with that, would you not?
Yes, I would agree, Your Honor.
So we have a pleading that framed the case, and the court relied upon that pleading, and thank you for conceding, the affidavit didn't amend that pleading. So I'm just trying to understand how the pleading does not undermine your argument. But yeah, just help me appreciate that.
As I mentioned, the issue was about rezoning. The pleading referenced a PUD. There was another rezoning that was in the affidavit. That was before the court. The court, had the opportunity to consider that. I would submit that the pleading, while it does frame the issues, that this issue is related enough to what is pled that it should be considered by the court, and so that this case can be decided on the merits of what actually occurred versus, formalized, overly formalized review of what's in the pleadings.
I'm sorry, good.
Did any of the addendums to the contract mention COVID or the pandemic?
No, the only addendum that was signed after the pandemic had begun was the sixth addendum. So all prior addendums, of course, didn't mention anything. The sixth addendum, the testimony, the record evidence was the parties were not negotiating that over COVID. That was just another extension of the feasibility study period. There's nothing in Addendum 6 that references either the pandemic, COVID, the force majeure provision. There's nothing in the document by which the parties evidenced any intent to do that. And actually, the testimony of Dwight Griffiths, again, the lead negotiator, was that the Addendum 6 had nothing to do with COVID, the pandemic, or the force majeure provision. So I would submit that Addendum 6 didn't change or amend the paragraph 12, the force majeure provision, because the law in Florida is obviously when something's amended, if the underlying contract's not addressed by the amendment, that portion of the contract stays in place and still is enforceable.
At the time Addendum 6 was entered, is it undisputed that the Building and Zoning Department of Nassau County government was fully operational?
I'm not sure what you mean by fully operational. They certainly had
Wasn't
started.
closed, they were operating, they were open for business.
It was, I believe it was closed to the public, and I know that they had canceled certain meetings to that point, and it was unknown whether future meetings would be canceled at that point.
I know you're almost in your rebuttal time. Under your reading of paragraph 12, the force majeure clause, when did that end? When is COVID over? Are you still under the extension now? How much time if force majeure applies, how much time do you get?
Well, essentially, Your Honor, what we would ask for is the time that was lost. My client was supposed to have an additional 6 months of extension that was bargained for. Significant chunks of that were lost due to COVID, due to the 53-day delay in the county's response, and due to the slowness of responses related to the land swap issues in those discussions. They essentially didn't get what they bargained for. And so we would submit that the force majeure clause should apply in this case.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. If it please the court, my name is Clyde Davis. I represent the defendant appellees, in this case, Louise Williams, Dwight Griffiths, and Richard Griffiths. First, let me expand a little bit on what my colleague was speaking to, which is this PUD application that is mentioned in the lawsuit. That PUD application encompassed more land than just the land contracted to be purchased from my clients. But I'm going to peel the onion down real quick. This case is not about COVID, regardless of what the plaintiffs plead. This case is about money. This case is about really 2 checks that the plaintiff appellant needed to write. The plaintiff appellant needed to write a check for approximately $6.25 million to mitigate or achieve concurrency with Nassau District Schools. The plaintiff did not want to write a check for that amount, and that's why it got engaged in these discussions about a land swap to achieve that concurrency. But starting out the box, the plaintiff had to write a check. The failure to write the check is not driven or obstructed by COVID. The second check the client or the plaintiff needed to write was a check for almost $3 million, a check for $2,950,000 to buy my client's property so it could be rezoned to whatever purpose the plaintiff appellant sought. That's what this case is about. As the court found in its order on summary judgment, there are reasons and there are excuses, and it's important to know the difference. I'm expressing what I think the court was saying. And the court said, you filed a lawsuit alleging that the COVID-19 impact is the failure of the Planning and Zoning Board to meet, which prevented you from moving your application forward. On summary judgment, it was clear and undisputed that the failure to move the application forward was not COVID-19. The failure to move the application forward was the plaintiff's failure to achieve school concurrency by writing that check. And it was unable to achieve some other mitigation or concurrency in lieu of writing that check.
Well, what about counsel's contention that but for COVID, there would have been more time to negotiate this land swap for satisfaction of the concurrency requirement?
Great question. If you look at the record in this case, and it is particularly a series of emails attached to the affidavit of Mr. McDowell on the transcript of his deposition, you will see that before the April 30th, addendum number 6, the plaintiff is already engaged in those discussions, and you will see that there has been a delay directly attributable to COVID-19 before the parties contracted in addendum number 6. And so what we know is, in this situation, COVID-19 is a known quantity that is affecting those negotiations before the plaintiff and my clients contract to close by November 30th. It is a known quantity that is affecting the negotiations. And because it is known to the parties, not just perhaps in the abstract because it's on television, or because the governor of the state of Florida has declared an emergency, the Board of County Commissioners of Nassau County has declared an emergency, and because the Planning and Zoning Board has already started suspending meetings. The parties know these things, and it's affecting that negotiation that the plaintiff is talking about. And it is with that knowledge that the parties say, what? That the period of time for the period for investigation will continue. They don't use the word in addendum 6, period. They use that the study will continue until October 30, and you will close by, or the study will study, not study period, but the study will continue till October 31st, and the closing will be by November 30. And what else do they say? The parties specifically say the seller, the defendants, the appellees will not agree to any further extensions. And the plaintiff signs off on that agreement. So it is with the knowledge of COVID-19, not just in the abstract, not just because it's on the news, not because the governor has said that it is a state of emergency, but even with knowledge that it's affecting your own negotiations, they contract to close. What else do they know? If you look at the record and you look at what is appended to Mr. McDowell's deposition, which was filed by the plaintiff 4 days before our hearing, what do you find? You find out that on April 2nd, Nassau County Planning and Zoning has told the plaintiff, your application for a PUD is complete except for you achieving concurrency with Nassau District Schools. So we know on this record, and the court knows on the record, that what has blocked any movement of the application for the PUD to Planning and Zoning Board is one thing. It ain't COVID. It's you haven't gotten your school concurrency. What else did the county tell them on that date preceding addendum number 6? Told them you've got 6 months to get it done. Now, so with the county Planning and Zoning Board suspended, the county is telling the plaintiff, you've got 6 months from April, let's just say the first week in April, to get it done. In effect, the plaintiff knows it has until September to achieve concurrency. What does the plaintiff do? The plaintiff and the defendants get together and say, okay, we'll extend the study out to the end of October, but you're going to close by November 30th. That is how these time periods evolve, and that's how addendum number 6 to the contract comes into existence.
Can I ask you, counsel, you seem to be in agreement that the time for completion of the feasibility study, you agree that it was extended out to the end of October 2020?
The time for the plaintiff to continue with examining how it wished to proceed was extended out. But where the plaintiff and I disagree is this. The contract is specific as to notices that must be given. And what the contract says is if you don't give this notice by the end of that period, then you have accepted that piece of property as is. Why is
And
that?
when would that have occurred under the facts of this case?
I'm sorry?
And when would that have occurred under the facts of this case?
Actually, the court finds it has occurred twice. And it sets forth that finding with specificity in its order. I don't bring it to mind, but I believe it was at the end of the feasibility study period at the end of addendum number 4. That was specified in addendum number 4. It happened again at the end of the period, whether it's study period or just a study. There's no notice given to the selling party, my clients, at the end of October in 2020. That is to say, October 31 rolls around, whether it's feasibility study or feasibility study period. The plaintiff did not give the notice required under the terms of the contract to trigger rejection of the property. The court, in its summary judgment order, finds that this has already occurred and that there is nothing in any of the subsequent addendums to walk back that prior acceptance of the property as is. Why is this important? It's important because the contract itself doesn't require the property to be rezoned. There is no rezoning contingency found within the 4 corners of the contract or any addendum. In fact, addendum 2 and addendum 4 to this contract say to the contrary, that you can't have it rezoned until after you've paid us for the property.
I'm not understanding, why would the parties agree to extend the feasibility study period if the deal is already going to go through, if the closing must happen then?
The defendants in this case wanted the deal to happen. They wanted the plaintiff to have an opportunity to do the deal.
I can understand that, and certainly extending the closing date would allow that, but why would the feasibility study time period be extended, but the property must close?
Well, I was not there, so I don't know what the thinking was, but what I do believe the thinking was is what I tried to explain before and did poorly, was that Nassau County has told the plaintiff in the early part of April 2020, I think either April 1st or April 2nd, in writing, your PUD application is complete, but for your school concurrency, and you have 6 months from the date of this notice to get that done. I suspect, because it fits with the actions of the parties, that they sat down and said, okay, we have 6 months to get the school concurrency done from first week in April. Here's our time period. Get everything done, we'll close. And I would just suggest to the court, it's not in the record, but a reasonable seller who wants the transaction to be completed would do exactly what they said in addendum number 6, which is, all right, we'll extend our study period out to the end of October and we'll close by the end of November because we're working off of that notice that the county has given you in the first week of April saying you've got 6 months. I don't know that to be the case, but it makes sense. It is consistent with what is in the record.
The final issue the plaintiff argues, the appellant argues, is that the trial
Your Honor,
court...
I'm sorry.
The final issue the appellant argues is that the trial court erred in accepting the affidavits and exhibits that were filed after the motion for summary judgment. Assume for the sake of argument that we agree with the appellant, then can we still affirm the trial court, and if so, on what basis, or must we reverse the trial court?
Well, as the court knows, the rules changed on us in regard to summary judgment after the motion for summary judgment was filed. And so the new rule required us to recite in the motion for summary judgment. Had the new rule been in effect, we would have had to put in all of the information to be referenced prior to filing or at the time of the filing of the motion. The old rule allowed us to supplement whatever was in the motion for a summary judgment, which is what the court allowed us to do. It allowed the plaintiff to even supplement the record 4 days prior to the hearing. Again, the court is faced, it's got a trial schedule. The court opened the door and said, bring everything in. If the old rule is followed, the plaintiff is perhaps across the line by filing only 4 days prior to the motion for summary judgment. The court let him do it anyway, and we didn't object. If we're under the new rule, none of what the plaintiff filed in opposition to the motion for summary judgment would have been considered by the court because all of it was filed after that 20-day line that is in existence today under the rule. That is to say, if we followed the rule as promulgated by the Supreme Court in May of that year, then the plaintiff, the appellant, had until a point in time, 20 days before the hearing, to get all of its summary judgment evidence in. when that 20-day line was crossed, there was no summary judgment evidence for the court to consider as coming in from the plaintiff. So what the record would have been, applying the new rule to the motion for summary judgment, would have been, there's no summary judgment evidence from the plaintiff that contradicts the allegations in the summary judgment motion filed by defendants. In other words, the court would have ruled that way anyway. So I will submit that the only way that the court, in the exercise of its discretion, could get everything in for its consideration was to open the door and say, put it all in, I'll sort it out. And I think that's what the court did, because it makes reference to those items filed by the plaintiff 4 days before the summary judgment hearing. It makes extensive references to that in its order. I believe my time is up. I thank you so much.
And thank you, counsel.
Hey, please, court. Just wanted to briefly address some of the things that counsel mentioned. One was that the record reflects that on April 22nd, 2020, that the county indicated that the application is complete. That is true, but the record also reflects that on June 19th, 2020, that the county asked for an amended application from the appellant. So presumably the process was still in flux because they asked for an amended application. It was thereafter that they did not respond to requests related to that amended application for approximately 53 days until August of 2020, which was the first time they advised that the land swap was no longer acceptable. The issue about the feasibility study period, there were two extensions of the feasibility study period. The trial court found that it expired in October of 2019. Certainly any reasonable seller would, if the closing was required to happen, would not give it another year and a half if that wasn't the intent of the parties to extend the feasibility study period. And there's conflicting record evidence about the intent. In fact, Mr. Griffiths, Dwight Griffiths, testified that he did intend to extend the feasibility study period by those addendums. The issue about the payment of the money, the $3 million purchase price, my client bargained for a feasibility study period to determine if the zoning could be achieved, without which the property is not worth the price that would have been paid. And so that's why my client, appellant, needed that additional time that it bargained for, and why it's here today, because that time was lost due to the effects of the COVID pandemic and the way that the county responded to those effects. And then just briefly on the issue of the summary judgment evidence, there's one big difference in what was described is that I objected to the untimely affidavits at the hearing and in the response, and there was no objection to the submission of evidence by the
trial
appellant.
judge asked you about prejudice, how you were prejudiced by that filing 3 or 4 weeks before, and I didn't see a response. Was there any allegation that your client was prejudiced by that arguably untimely filing?
Well, there was evidence that frankly was conflicting with record evidence that we submitted that I would submit. It creates disputed issues of fact. But as far as prejudice, we did have the opportunity to depose both of those affiants. So with respect to that, I would say there was no prejudice.
Appreciate your candor.
So for all the reasons, we would ask that the court reverse the summary judgment and remand to the trial court to allow a trial to proceed on the merits where the factual disputes can be decided based on testimony and evidence rather than cold deposition transcripts and affidavits. Thank you.
And thank you, counsel, for your respective oral arguments this afternoon. This concludes our oral arguments for this afternoon, and we stand adjourned.
All rise.